Despite this emphatic warning, Strode did precisely what Laughlin advised him not to do. He drafted the Virginia law to apply to what inmates of the 5 Virginia hospitals for the feeble-minded: Western State Hospital, Eastern State Hospital, Southwestern State Hospital, Central State Hospital for Negroes, and a colony for epileptics and feeble-minded. Strode, who was a highly skilled lawyer, had researched the issue extensively, knew that limited knew that limiting the law in this way would make it vulnerable to equal protection challenge. Um, the question is why he did it. It is possible that Strode was simply acting as an advocate for his clients. He represented the state hospitals, and he drafted a law to let him do all the sterilizing. It would not help him, however, if the law he drafted were struck down as unconstitutional. Another possibility is that Strode did not believe the legislature would pass a law that applied to everyone in the state, but he thought it might help his narrower vision. But this was unlikely, given how little opposition there would to prove in the legislature. There are two more possibilities, which suggest degree of reluctance on Strode's part about eugenic sterilization. One is that Strode thought a sterilization law that applied to a whole population of the state would go too far. He may not have been comfortable with making every Virginian eligible to be sterilized by the state. By limiting his bill to inmates of the state's 5 mental hospitals, Strode ensured that only a few thousand people would be eligible for eugenic sterilization rather than millions. A final intriguing possibility is that Strode may have supported eugenic sterilization and might have not have supported eugenic sterilization and might have intentionally written the law in a way that made it vulnerable to being struck down. Strode was the brother of 6 sisters and a champion of women's rights. He was also someone, as a member of the legislature, had not spoken out in favor of eugenic sterilization or introduced a bill of his own. In fact, on that day, Dr. Carrington's eugenic sterilization bill came up for a vote. Strode was present in the legislature and voted on 30 other bills. He was, however, apparently absent for the vote on the sterilization bill, hardly the act of a man who thought the state desperately needed eugenic sterilization to save itself from ruin. Seems like a good dude so far, I guess, maybe. If Strode was trying to understand his own bill, he did one more unusual thing that could help to prevent it from ever taking effect. Strode strongly advised the state hospital board that if the eugenic sterilization bill passed, the state hospitals could not carry out any sterilization until the law was tested in the courts, all the way up to the Supreme Court, if the case got that far. Uh, it was unusual advice. States generally act on laws once they get passed, rather than wait for them to be tested in the courts. Perhaps for years, Strode might have given this advice out of an abundance of caution, or he might have wanted to give the law he was hiring to draft every chance to fail. Strode gave his bill, formally titled an act to provide for the sexual frustration of inmates of state institutions in certain cases, to the chairman of the Senate Committee on Courts, Marshall Booker, to introduce in February 1924. Dr. Priddy and John Arnett both testified in favor of it. Governor Trinkle also used his influence in the legislature in support of the bill. Whether or not there was a change in popular opinion, as Dr. Priddy had said, there had clearly been a change in legislative opinion. Strode's bill became law on March 30th, 1924, after passing the state Senate unanimously and the House of Delegates by a vote of 75-2. Dr. Priddy's and Dr. John Arnett's years of persistence had paid off. This proves Abraham Lincoln's theory that, quote, nothing is ever settled until it is settled right, Dr. John Arnett would later say. Even though eugenic sterilization was now the law in Virginia, no sterilizations were being scheduled. The state hospital board accepted Strode's advice, and it decided that none would be carried out until the law could be reviewed by the courts. Proceeding as Strode's advised required that a challenge be brought to the new law's constitutionality. It was unlikely opponents of the law would emerge to do this on their own. Uh, there was no organized opposition in Virginia to eugenic sterilization, and there was no national advocacy group working against such laws, nor was there reason to expect any of the inmates in Virginia State Hospital would be as assertive about their rights as the Mallorys had been. It would be up to the new law's supporters to put together a test case, and one they could win. Dr. Priddy became the architect of the case challenging the constitutionality of the law he had just worked years to enact. In taking on the assessment, he was thrusting himself into a larger stage. When he began, Dr. Priddy was only seeking a legal authority to carry out sterilizations on his own institutions without the risk of being sued. Now he was putting together a case that would go as far as the United States Supreme Court. Um, Dr. Priddy, who had been born in rural Lunenburg County and educated in a four-room schoolhouse, might be helping to establish eugenic policy for the whole nation, and given the role in United States played in setting eugenic policy for the world. True to his methodical nature, Dr. Priddy moved deliberately through a checklist of necessary steps. He began by obtaining the approval of Colony Special Board of Directors and the State Hospital Board, and he persuaded uh, the hospital board to finance the litigation. Dr. Priddy had to retain a lawyer, but there was no real doubt about who that would be. Um, Strode also had been critical to the founding of the colony, and he had done its legal work for years. Dr. Priddy and Strode were also friends of long standing, and Strode knew more about Virginia's sterilization law than anyone. The next big task was choosing someone to sterilize and to put the center of the stage. Dr. Priddy and his allies had a large pool to choose from. The law applied to all inmates of the state's 5 mental hospitals who were afflicted with hereditary forms of insanity that are recurrent, idiocy, imbecility, feeble-mindedness, or epilepsy. Based on the statutory criteria, there were thousands who qualified. It mattered a great deal, however, who was chosen. As Strode had explained, eugenic sterilization laws were meeting with considerable resistance in courts across the country, and it was far from certain that the Virginia law would survive. The law's supporters needed a subject who would make the best possible case for their side. Someone a court would decide was well deserving of eugenic sterilization. Dr. Priddy had hundreds of his own inmates to choose from, male and female, young and epileptic, and feeble-minded. It did not take him long, however, to set his sights on Carrie, who had been at the colony for less than 2 months. There, who were many reasons she was ideal. There were many reasons she was ideal. To begin with, she presented a strong record of feeble-mindedness, and Dr. Priddy had the medical records to prove it. Carrie had been legally designated as feeble-minded by a commission of feeble-mindedness after a hearing conducted by a judge and 2 doctors. The colony had then made its own assessment that Carrie was a moron. If called on to testify, Dr. Priddy could personally vouch for her mental defects.